Yes, Miss
Yes.
Macklin.
My Lord, I was addressing the court in relation to the relevance of the judge's interpretation of the guardian's position. I had just said in any event, but before I come to that, in terms of whether really His Honour Judge Wicks was of the view that there was a very significant difference in the position of the guardian and the local authority, I would just like to draw the court's attention to paragraph 39 of the judgment at A111, where having considered the guardian's position, he says, however, she does say that the court should not at this stage consider whether adoption is the right option.
Yes, actually.
So to that extent, she departs from the local authority's position. I say it's not. There isn't. He was obviously aware that there wasn't a significant difference between them. But in any event, perhaps the more important point, the key point.
How does that tie with long term? Sorry for interrupting.
Yes.
How does that tie with long term with paragraph 5?
Well, I say what he's describing as long-term foster care is that gap in the middle. If this child is in foster care for 6 months, that is effectively being in long-term foster care under a final care order, with the risk that it could break down because the foster carer might give notice with 28 days in the usual way.
Does that really chime with what he says at 36, where he cites Mrs. Justice Cobb? That's not talking about a temporary arrangement. That's
It's not, but of course it might have been. We simply don't know. We don't know what the assessments are going to be. What if the adoption assessments are negative? What if the foster carers changed their mind? Because they had been talking about special guardianship. There were issues about finances. And again, I make it absolutely clear, no criticism at all of the foster carers in this case. The mother is very grateful to them for the care that they've given to the child. And she recognises it as a good placement. So there wasn't any guarantees. And what then? Well, the fallback position would have been long-term foster care. But the more significant point is that the judge was clearly aware that the guardian did not support return to the mother.
Yes. So nothing turns on this point.
Nothing turns
Is your perhaps your stronger point.
Yes.
This was an extempore judgment, was it?
Turn my back.
Somebody said it was earlier. I think Mr. House.
Overnight, I'm told.
Overnight.
He had written submissions.
Extempore is a bit of a loose phrase now, isn't it?
His written submissions, he had the oral submissions, if we can call it that, on the 19th, and then the judgment was handed down on the 20th.
Okay, it wasn't extempore. Anyway, your point is, you emphasised the point that nothing turned on this.
No.
If there was, insofar as there was any lack of clarity in his understanding.
When one looks at his analysis of the pros and cons of adoption, one doesn't find there, and by the way, the guardian doesn't support it.
Right.
So, my lords, I do turn on now to the judge's analysis of the various options. I've touched on this already, so I'll try not to repeat myself, but he does obviously set out the law correctly in terms of needing to consider the pros and cons of each of the options and then consider them side by side. At paragraph 29 of the judgment, he considers the benefits of placement with the mother and makes a number of very obvious and uncontroversial points. At paragraph 30 then, he deals with the negatives in terms of placement with the mother, which of course relate to the risk of domestic abuse. He identifies the risk of the mother resuming a relationship with the father, or even if she doesn't, not being able to say no to the father, so an important distinction that he makes there, or that the mother might engage in an abusive relationship with someone else. And in terms of the impact on the child, he identifies emotional and physical harm and says that that's obvious. And I've already addressed the point about he's obviously aware of the risks because he's addressed it in the threshold document. And he then considers what can be put in place to mitigate those risks. And he considers the local authority's position in relation to that at paragraph 31 and 32, and sets out at 33 and 34 and 35 why he rejects the local authority's position, and concludes that in fact the risks can be addressed in this case because of the progress that the mother has made. He then goes on to consider long-term foster care. Well, We've already touched on that. I say no harm in considering that, even if in fact it wasn't a realistic option before him. And as far as the guardian is concerned, at paragraph 37, fundamentally his disagreement with the guardian, paragraph 37 and paragraph 38, is that he doesn't agree with her assessment of risks. He says at the conclusion of paragraph 38 that he considers the positive changes, the agreed facts, tip this case, this finely balanced case, into a positive conclusion in respect of the assessment of the mother, and he doesn't agree with the guardian in relation to that. And he then considers the benefits and detriments of adoption at paragraph 42. Now, he's criticised for not reflecting that there's a possibility, as far as an adoptive placement is concerned, that there could be ongoing direct contact if the child remains in the current placement. A couple of points about that. First of all, he was being asked to consider adoption in principle. He's clearly aware of the possibility of an ongoing contact between the mother and the child. He knows that foster carers are willing to agree to that. But if one looks at the local authority's February statement, as the court has looked at already, that's in the supplemental bundle, page A67. One of the things that the local authority says in the detriments against adoption is the local authority would support the child's current foster carers to engage with adoption assessment. However, it can't guarantee that the current placement would be her adoptive placement and she might be matched with another family. And they say that the minimum contact would be letterbox contact. So we say he's not wrong to refer to that. And in any event, even if there was ongoing direct contact, it's right to say that that would be a loss to this child of a legal relationship with her birth family. So he sets out the positives and negatives of adoption, and then at 43, paragraph 43, that's the judgment, he says when he weighs the positives and negatives against each other, he's driven to the conclusion, he's not driven to the conclusion that nothing short of adoption will do. So he does go through those steps. And we say that although he does use the phrase, he's driven to the conclusion that nothing short of adoption will do, that's having carried out an analysis of each of the options, albeit brief, I accept that. And having arrived at a conclusion, he's not using that phrase as a shortcut. There's still a direct route to an outcome in this case, but it's a cross-check, having already carried out his analysis. He's criticised, my lords, for not making specific reference to the welfare checklist factors, but in our skeleton argument at paragraph 60, we say that in fact if one looks at the judgment and looks at the various factors in the extended welfare checklist, he's addressed the vast majority of them. Now I accept he doesn't make reference to the child's wishes and feelings, but in light of her age, that's perhaps not that surprising. He doesn't make any reference to particular characteristics, but there weren't any. I'm not going to go through what I've set out at paragraph 60, which is at A77 of the core bundle. But we say, in short, that if one looks through the judgment, he has considered all of those matters. He does address the child's relationship with the foster carer and the impact, for example, of her ceasing to be a member of her birth family and being an adoptive family. So he has addressed those points. Ultimately, we say that this was a finely balanced case. As the local authority itself says, it's not possible to say that the judge was wrong. Their concern is about the lack of reasons in this judgment. The consequences of interfering with this judgment, I know the court is all too aware of. This is a case where, through no fault of the mother or the child, there has been very, very significant delay. And that, of course, is why it's not enough just to say, well, it's not a good judgment. It has to be so unsatisfactory that it's wrong for this court to interfere with it. We say that when one looks at it, one can see that the judge ultimately addressed the issue at the heart of the matter. He was aware of the risk. He came to a decision which was different to that of the local authority and the Guardian in relation to how those risks could be addressed. He was impressed by the significant changes that the mother has made, and he was entitled to come to that conclusion. And so we say that the appeal can't be allowed. In the event that it is, we do say that the court ought to list a directions hearing so that very careful consideration can be given to the issue of further assessment, and it's helpful.
So you wouldn't encourage us to attempt to make case management directions?
Well, we don't, of course, have any Part 25
No,
applicants.
but you would be, that's right. You need time, you would need time in those circumstances to consider that.
Yes,
And-
but fundamentally, we say that there's a disagreement because the local authority and the Guardian have nailed their colours to the mast. They say that the changes that the mother made weren't enough.
Well, they nailed their colours to the mast as of March.
Yeah.
By the time, if we were to allow the appeal and order rehearing, it would be a further 6 months on. And I don't hear the local authority, or for that matter, the Guardian, ruling out the possibility that that they may reach a different conclusion.
No. When I turn my back very briefly. Unless I can assist the speaker.
No. Anything else? But we're very grateful, Ms. Macklin. Yes, now, Ms. Reid. Very pleased to see you. We were slightly, forgive me for saying so, raise an eyebrow at seeing leading counsel for the father, given the father's limited position.
Yes, well, my lord, there was a query until very late about legal aid. I had already prepared by the time the decision came through, so I'm here to assist as best I can without repeating what has already been said on behalf of the mother. As the court knows from the short skeleton that my junior prepared, we adopt the submissions and the position of the mother, and I make the same clear in respect of the oral submissions that have been made today. I adopt those submissions. If I may, I will try to assist by just emphasising one or two of the points
Yes.
that have come through in today's submissions. The focus of the attack on the judgment and the decision is on the evaluation of risks and how that was factored into the welfare analysis. And this court knows that the evaluation of risk is based upon facts, that risk is not static, and that facts and thus risk shift over time. And ultimately that evaluation of risk is for the judge. If I may, to assist the court, my understanding of the background and that evolution of bits of the final hearing from October through to March appears to have followed an unusual track. In October, the point when the court was hoping to run and conclude a final hearing, the foster carers issue, if I can put it that way, emerged, and at that point there was a question mark raised about special guardianship, which would have been, had the mother not been able to care for the child, an alternative short of adoption. And that's what was raised at that point and was one of the issues that troubled the judge that led to the adjournment in the first instance. It prompted questions and thought about whether adoption could be said to be necessary if there was a possible less draconian alternative in the wings. And so the focus, it appears from reading the papers, was upon alternatives to adoption other than the mother, who the local authority and Guardian were saying still presented too much of a risk. That seems to be why, ultimately, the local authority adopted the unusual position of saying that it would not pursue its extant placement order application, it would put it to one side, but it would invite the court to make a decision about adoption in principle. That's the way that it was put to the judge. And that's the background to the care plan that the court has at A80, which talks about the technicality of nothing else will do. But I flag for the court that it doesn't appear that that care plan is in fact the final iteration of the care plans, because we know that there was a further version that referred to the social worker's concession in October about direct contact, and it's not in that plan. And we also know that it took some time to disentangle the foster carer's position, whether they were seeking special guardianship, adoption, what their preferences and priorities were. And that seems to have become the focus of thoughts about how the hearing should proceed, what the care plan should look like, what the structure and shape of the submissions should be. But all the while that this was happening, time was ticking on and the facts and the risk were gradually shifting. It seems to be the case that the Guardian and the local authorities' positions were not quite the same. That the Guardian's position was she favoured the foster carers caring for this child in the long term on some basis, preferably adoption, but not necessarily, and that the local authority preferred adoption by somebody, preferably these foster carers, and they're not the same, and the care plan doesn't deal with that issue either. But ultimately, the judge was asked to make a decision about whether or not adoption in principle was necessary and proportionate, and that is, in my submission, what the judge did. And he did so, reaching the conclusion that it was not necessary and proportionate because of his evaluation of the risks as they presented at the point of his decision. The court had a clear and detailed understanding of facts, as we are told in Ruby it requires to have as a basis for its evaluation. This judge made all of the findings he was asked to make by any party. His decision is based on an entirely agreed factual background. He made the threshold findings that were sought, which did not include specific pleadings about dishonesty, concealment, etc. They are agreed threshold facts. He relied upon the agreed subsequent facts that were put together in March, and which I understand were in circulation in one form or another from about the 5th of March. And no party said they wanted to challenge those facts, to seek other findings, to reduce evidence, to properly contextualise the findings that they knew that the court was being invited to adopt. They could have done so, but no party did that. Each party elected to invite the court to make its decision based upon the evidence it had heard in October, the agreed threshold facts, which related primarily to 2023, but also incorporated some subsequent facts as the case had proceeded, and the subsequent post-October agreed facts. So the court had a full run of key points of fact that the parties wanted the judge to look at. And the simple fact is, Your Honour, and I won't repeat what my learned friend has said about the way in which the judgment is structured to go through the analysis, the options. The simple fact is that the judge's primary evaluation of risk was different from the local authorities and from the Guardians because of the attention he paid to the change between October and the point at which the matter came back. And those matters are not addressed or engaged with in any substantive detail, either in the February statement of the social worker, which in fairness to her, I think was prepared and filed on the day of the sentencing. In the written submissions or in any subsequent statement or report, no party sought to reduce a statement from the independent domestic violence advocate, etc. That's the party's election. That they took the view that it was not necessary to invite the court to do anything further, but to rely on the material. And so, my lord, the evaluation of risk that the judge undertook was a correct evaluation of risk at the date of his decision, and a sufficient evaluation of risk as at that point. I don't think, my lord, that it will help for me to repeat what has been said about the sequencing and the contents of the judgment, save to say that I adopt what has been said and endorse what has been said about the way in which, in the course of the judgment, each of the key points under the relevant checklists is visible and identifiable. The judge has identified the checklists, he's identified the law, he's followed the steps that he has identified, and he has reached his conclusion. I think beyond that, my lord, I'm going to be really trespassing on repetition.
Thank you, Miss Reid. Yes, now, Miss Brown. What do you want to say in reply?
Very little, my lord. Just dealing with the question of the judgment. It was not written, so it was the following day and delivered orally.
Thank you.
The transcript, I think when it was permission to appeal was granted by Lord Justice Peter Jackson, that was on the basis of the agreed note of the judgment, counsel's note that had been agreed by His Honour Judge Wicks, and then we had the full transcript to follow. So it was delivered orally the second day of the final part of the final hearing. Just dealing with one point in relation to the children's guardian's position. It is also referred to at A90 in Ms Pollock's written submissions, because she begins the document at A89 just setting out basic information, and then provides at A90 an outline summary of the closing positions of the parties. And you can see there clearly the Guardian supports the local authority amended final care plan, that is for a final care order to be made. And then the Guardian has confirmed that it is her opinion that the current placement with the foster carers is the best placement for the child. So however one looks at it, in my submission, paragraph 5 of the judgment just is clearly wrong. It's not correct. And that follows through the judgment. I won't in reply repeat my arguments and submissions, our arguments about the assessment of risk, but I do wish to just take your lordships to the statement from the social worker in the supplementary bundle at A61. We've looked at this already today, but this is the updating statement, and it clearly sets out the ongoing work of the allocated social worker on the ground with the mother, her knowledge of what was happening for the mother. It reports in discussions with the mother, despite referring to the programme of work positively and explaining that she feels like she would now make better decisions, the social worker sets out her concerns. And that is borne through in the remainder of that statement there, and it reminds the court of the history that the mother had been in that position before, where she had everything in place. And then I would ask your lordships to look at, because what we see here at A61, the primary point that the social worker makes is until the mother is able to take responsibility for her actions, she will not effect second order change. And that is fundamental to the evaluation of risk. And then when one looks at the
Where were you reading from there precisely?
A61,
Yes.
following on down through the middle paragraph, it's the allocated social
I'm sorry.
workers
Thank you very
comment about second order change. And there we have the evidence, and it is evidence, it's hearsay evidence, but it's admissible evidence from the mother's IDFA worker that was highlighted in the final submissions to His Honour Judge Wicks. And of course, because we do not have in the judgment the judge's comments on the evidence, we don't know how he reflected that back to the oral evidence he had heard in October. But in the transcript of the mother's evidence at A207, we have a clear example of what is identified there by the social worker in her statement of the mother not really taking responsibility. And this is an examination in chief at the top of A207. And the mother is asked for her to say what she wished to the judge about why the child should return to her. And you get the equivocation, this semi-responsibility, acceptance of responsibility by her. Look, my submission is part of the social worker's assessment and what the local authority wished the judge to engage with in his assessment and evaluation of risk.
What she says is Jacob was partly the problem, obviously myself as well.
Yes.
So it's not saying he was wholly the problem.
No, not saying wholly, but the equivocation in the acceptance of second order change, the steps she could have taken. Because of course, and that's acknowledged by the judge in his judgment, one cannot necessarily stop a domestically abusive person from attending at your property. But if it's a property that is a confidential address, one major step in preventing that is not to give that address to that person. And then if they do attend because they found it through other means, that you immediately press the panic button and you report that contact to your support network, to the social worker, to your IDFA worker. But the mother here is a partial acceptance of responsibility, but not the acceptance of the steps she should have taken, could have taken, and ought to have taken. And that was the concern of the local authority. There just is no engagement by the judge in relation to these matters. No exposition of the oral evidence, of the written evidence that was voluminous because there was a long history. Unless there are any specific matters that arise from these submissions of the other parties, there's nothing more I wish to say by way of reply.
Thank you very much, Ms. Brown. Thank you, everybody, for your submissions, helpful submissions today. Thank you again for everybody sitting behind you for their preparation and work on this case. As I said at the start of the hearing, we're going to reserve our judgments. In due course, you will be supplied with a draft copy of our judgments, which will enable you to check for any typographical or other minor errors, not, of course, an opportunity to re-argue the case. Please bear in mind, as set out at the top of the draft, that it is sent to you under an embargo and must not be disclosed to anybody outside the agreed number of people it's being disclosed to. A breach of that is a contempt of court, as I'm sure you're aware. We'd be grateful if, on receiving our draft, you would also try to agree an order that reflects our decisions. If there are any matters on which you are not agreed, please submit short written submissions and we will resolve those outstanding issues on paper. Thank you very much.
Supervisor Cable,